Right, thank you. We will reconvene. Yes, we've reconvened. Now, we took a couple of minutes longer because we're having a bit of a chat, and Commissioner Bartlett has had one of those revelations that happen from time to time.
A penny drop moment, and Ms. Berrin's not even here to appreciate it because it's something that she was trying to tell us before she left. And the penny drop moment was there, which was that P1 is about the triggers, not about the assessment of effects. And I'm seeing the nod of relief from Ms. Bennett. The penny dropped eventually. So she was trying to tell us that, and when she gets to view this or someone tells you that, you can share the revelation with you that we got it. We did. It just took us a wee moment.
Her and I had a chat about that after you exited the room, so I'm sure she'll appreciate that.
What it points to, and we need to have some talkies afterwards about moving forward. To us, it appears that there is a good chunk of work that needs to be done, and we need to talk about the whole timing and impacts on reconvening the hearing as well. So, back in your hands.
Thank you. So I'm going to keep it short, but before we start, I'm mindful it's nearly 5. Everyone else seems to be perfectly fine, but I'm fading. So there is an option for the panel to consider that I can speak to my submissions now, but perhaps we can turn then to Ms. Bennett's evidence in the morning. So I'll leave that with you while we go through these first points.
And given that we now appreciate what the time is and we're still full of energy, I think that's a good point. I'd rather deal with your evidence in one chunk rather than have you on tenterhooks over.
What I do, yeah.
So in my submissions, we've talked about timing, subject to anything else you'd like to raise. I understand you haven't had them in advance, so I can speak to them or summarise them. What would you prefer?
Speaking and summarising in my language is the same thing.
Okay. Okay. I did say I was fading. But, so the initial section or issue that I address is the involvement of mana whenua in the proposed plan process. In my submission to date, the Council has reflected the fact that only mana whenua are able to identify what is culturally significant in their takiwā by providing for mana whenua to be actively involved in decision making on the relevant parts of the proposed plan. The intention has been that mana whenua can identify their cultural values and interests as best as possible in a district plan format, and that mana whenua will have significant input on the best planning responses to manage the effects of activities that may adversely or positively affect cultural values. I summarise there what evidence, types of evidence, Hokonui, the panel may take account of in receiving the evidence from Hokonui Runanga. It's called the something of reason. It's in this terribly large case, which I didn't provide you because it is so large. It's the rule of reason. It's a principle which has been developed to take account of in evidence on cultural values. So I've summarised that there. I will forward on this case, but only in electronic version because it is so long. I've got references there, so you can probably just go straight to those key points of the decision rather than needing to read the whole thing. Applying those principles, I then submit when considering any challenges raised in submissions that may be made against the values and interests of mana whenua, full weight in my submission should be given to the views of mana whenua. This was acknowledged as the correct approach in this Port Tauranga case. And the court said there, it is mana whenua that is best placed to identify the values of importance to mana whenua. And I then submit that you should apply that approach and take care in carefully listening to and applying the the suggestions of mana whenua in its evidence. Submissions on scope again, apologies. So that's a case law summary again, just reiterated there. I've probably amended my comments a little at the end at paragraph 15. If a plan provision or group of plan provisions have been specifically referred to in a submission, then I would submit there is likely to be a clear link and good notice given that the submission is seeking changes. Equally, a clear statement of a decision being support in respect of a provisional group of provisions is a key part of a submission, so is another direct route to identifying what a submitter wants. My friend referred to the outcomes, I think, of the provisions, and in this instance we have a name change, but in some respects the outcomes of the provisions are comparable. I would endorse that in this case. The parts of a submission that give explanations and reasons why a particular decision is sought add further context, and the panel may also refer to those in reviewing the submissions. So turning then to the scope of submissions on this topic, I would remind the panel that there is not one submission in this case that you are considering in relation to scope. There are a number of submissions that have expressed views, sought amendments, asked for relief, told you that they're interested in both mana whenua provisions and the chapter relating to sites of significance to Māori. So I would encourage you not just to look only at the Hokonui Runanga submission when you are considering issues of scope. And this comes back to a question that Commissioner Bartlett asked me this morning, is that when you are looking for a realistic solution to, as you move through the plan process, in this particular instance, you are actually fitting together potentially quite a number of submissions to find that realistic outcome. So don't confine yourselves to just the Hokonui Runanga submission when you're considering scope. I would also want to highlight in relation to provisions relating to cultural values that, as we've been discussing, there are a number of provisions relating to cultural values at different points of the plan. So I quite liked your wording this morning about talking about threads. So those threads are throughout the plan already. So any submission on cultural values actually is already spread through quite a lot of the plan. It's not just one chapter. You know, if you were talking about strategic objectives in the urban chapter, there's already a cultural values thread sitting in that chapter. So I would say sometimes you can pull that thread in a way that you might not if there wasn't already something in there before we started. So in my submissions at paragraph 17, I identify the issue which is a chicken and egg issue, which is the short way of saying it, isn't it? The difficulty for the parties in the panel at this point of the process is that scope issues are best analysed and determined when the final form of the provisions being put forward are clear or clearer. A key reason is that it needs to take account of all submissions on a particular provision or issue. So I am submitting that until other parties interested in this topic have provided evidence, proposed any further amendments, you've discussed those with those parties, it may be more prudent to reserve those more detailed scope analysis questions until that resumed hearing, which we are talking about potentially happening in February. So for the council and for my part, I'd prefer to carry out that exercise closer to that time when that evidence is available. So the next section is just about existing use rights. I would endorse my friend's comments in respect of any proposal that a provision might refer to existing use rights. I come at it from a slightly different point of view. In my submission, the role of section 10 of the RMA is to create and manage existing use rights. So that's what section 10 does. And in my submission, that provision of the Act should be the sole point of reference for understanding how those rights apply and how they work in any particular instance. any repetition or efforts to try and signal the intentions of that provision of that section in a district plan runs a significant risk of duplicating, creating confusion and creating inconsistency. So in my submission, I would also note that the way that provision is worded now might change, that way that provision is applied might change slightly in case law, and so in that respect I'd suggest the panel should be very reluctant to engage too much with that proposal moving forward. So apart from that, I should also note that Mr. Heal is also available to speak in the morning alongside Ms. Bennett, but I would just ask if you had any questions of my submissions.
I have no questions, and I think the explanation you gave there on existing use rights is probably a more succinct and helpful summary than what we've had in previous hearings. It's more to the point.
Might have been in a hurry.
So if there's no questions from other panel members in terms of what we've just heard, I do want to have a talk here then about timing moving forward, but I just want to flag for Mr. Heal that probably in the morning appreciate some feedback on the comment that I made earlier in terms of the role of the urban form and development chapter and whether there's some merit in objectives being included in that relating to what we're talking about today. So I'll leave that to the morning, but to flag it now. For Council, we talked before about the need for the two of you to get together to talk about timing moving forward, and I think it's clear that there is from a desire to see more work done, particularly in terms of the gap analysis and moving forward on that. And given there's effectively only 2 weeks of time left, given that, how does it impact on your thoughts in terms of timing for reconvening of the hearing, and is there a need to have some supplementary evidence come from Ms. Perrin, and also, yeah.
Can I just point out, so I have done a little recalculation of the dates if we were to resume on 18 February, and if I was to take the same approach that's in minute 28 at the moment, by my calculation that would suggest that expert evidence from other submitters would be due on the 28th of January. So that might be relevant in terms of, yes, we've got 2 weeks left, but we've also potentially got a bit of time then, expecting that they'd want to see that as well. So the timetable using the minute approach is 28 January, expert evidence from other submitters, 4 February, any supplementary 42A report, 11 February, any supplementary from Hokunui Runanga and legal submissions, and then resume 18 February at 12 o'clock. Waitangi is the 6th. Actually, I didn't check the weekend, sorry. Same date as the supplementary evidence.
Yeah, it is the 6th. And we observe it on the actual day now, don't we?
I might have buggered up that.
Which is
Wednesday.
Wednesday or Thursday.
So the 6th is a Thursday.
Yeah. Does
So
that
I think-
impact on your timing?
It was roughly a week for each step in advance of the
Yeah.
Tuesday when it resumes. Oh, that 4th doesn't sound right, does it?
So 11 Feb is what I got writing down for supplementary and rebuttal evidence, and hearing commence at 9 a.m. on what date?
Sorry, I had 12 o'clock, and this is wholly my fault in terms of my availability restrictions. I'd need to drive down, but I could break some speed limits, and possibly 11 would be fine.
Safety is everyone's responsibility.
So I can do 11, but
On what date?
that's the 18th. So that's the date proposed in paragraph C. It's the 18th.
Now, Mr. Hill, there's nothing else set down for that week, is it?
No,
No.
it's a gap.
So there's nothing to stop the panel meeting that day doing other deliberations and commencing at a time that suits you all in terms of your travel.
I'm easy. I can. I'm unusually flexible that week, and look, the timing's always an issue, isn't it? But I am conscious that there's going to be another busy hearing, and I don't think there's a solution to that. So I don't know why I'm raising it. But we're going to be attempting to fit a lot into a day and a half.
Yeah, so I guess coming back to you, the earlier in the day we can start, the
Yeah,
better.
so that's on me. So I will. I'll see if I can shift things. I'll have a look at that as well as an option. And I
Can I also just note that solving how much time we need is also going to be very dependent on how many people decide to put their hands up
Yeah,
on
on
the
the
13th of
13th.
December. And, you know, some may have watched this today and either come forward or gone away from the whole idea. So we won't really know until then.
well, that's a really important point, though. So perhaps it's an indicative timetable until we know, because if 100 people put their hands up, a day and a half's never going to work anyway. So perhaps this is an indicative timetable, and then I'm happy to confirm in a memo, which we put up online for further comment. And then if the panel so wishes, you could issue a minute confirming it post 13 December, subject to what sort of indication you have around that.
The other thing I was going to ask, and this will be something I think for Hokanui Runanga to respond to, given that we've just identified that important things are going to drop on the 4th of Feb, which happens to be right before Waitangi, and we know that that's a pretty important calendar date for Hokanui, that thinking about that, whether it's reasonable to stick to that 11 Feb evidence date, and whether it needs to shift, and what the implications would be if it's later that following week in terms of evidence due date. What are the implications there? Nothing's coming to me right now, but I'm sure somebody will jump in.
I'll jump in while others are thinking. I think Hokanui would be grateful for that, and it's for that reason of Waitangi weekend day, but also the fact that Ms. Beerin's task list has grown a bit, and that my initial concern with the February hearing being brought forward was her capacity to respond to the submitters' evidence, but there's actually, in addition to that, we're now going to be asking her to do her response to today, which is fine. So I guess perhaps if the panel was minded, we could move the 11th date out a couple of days to later that week to still give everyone a chance to read Ms. Beerin's supplementary before the hearing, but just give 2 more days to do that. I mean, in terms of process, I think the supplementary isn't going to be changing the approach or changing the direction of travel from Ms. Beerin's position. It's really more analysis-led. So I don't think there's sort of a procedural issue about that being filed slightly closer to the hearing than a full week before.
Can I just raise a question here? It's around, we don't know the volume of evidence we're going to get in, right? And so if you make it shorter, that's going to put pressure on everyone. So just have a think.
Yeah, but we don't know the volume of evidence we get in any hearing.
And I'm picking
I think
that
the 13th.
Courtney would want to do some supplementary evidence following receipt. And
Well, we've had so many steps by that stage.
Yes.
I'd hope it would be nothing more than an addendum similar to what we did.
yeah, and it's important that anything
On the 13th?
produced before the hearing is not a summary of the evidence, but just highlights points that you want to add to. So from my point of view, if council is to prepare a memo that is lodged,
Sorry, important point, and I was just got straight on that. Apologies.
all right, so if you were to prepare a memo for circulation going online with draft dates and response,
Yes.
and then following the 13th,
Yeah.
when we've got the numbers and names, bearing in mind that when you look at the number of submitters that are in the report, we're only dealing with tens, not hundreds. Yeah, we'll have a better understanding then.
And I might just also note that as we did for McNabb, we can give the panel an indication on our sort of estimates on hearing time in advance. If we need to bring it back on, we can start talking about those things for the panel to then consider making alternative directions, which again, that 13 December is quite a critical date as it turns out, to hear how many tens or so might be coming. But I am hearing Ms Bennett being concerned about turning any addendum down around, so it may not be in writing. Yeah, it may not be in writing. There's a lot of steps there, but we would probably have to confer before she'll be happy with me submitting anything like that.
And so we don't want to give grace on one hand and cause pressure on another. I think we want to get a happy place where everyone's able to hang on with some. It's all of this is difficult and pressured, so I just want to acknowledge that.
One thing we can do is between council and Runanga at least is Ms Beran, I'm sure will have an open dialogue with Courtney, and that will mean Courtney knows what's coming on the date to be confirmed in the week of 11th. So I think that might help. We could get some work streams overlapping a little bit. Yeah, that's fine.
The only other option would be to push the 28 January date back for submitters' evidence, and that would give us more leeway at the close to the hearing end.
So the statutory shutdown ends on 20th of Jan. So
10th of Jan.
10th of Jan.
20th of December to 10th of Jan.
Oh, sorry. Yes. Well, yes. Okay. Maybe that's not out of bounds, but I guess this is another thing that until you float something and get some feedback and know how many submitters are involved,
Well, might I suggest we take those 2 extra days that we're worried about here, push them into, although that's a Tuesday, which will take us, maybe even we just take 1 extra day, to the 27th of January. So I'll put that memo, but this is an ongoing conversation, obviously, so apologies that it's becoming so complicated, but yeah, we just want to make sure that Christmas isn't interrupted. We've all been working hard.
We'll be doing this over Christmas though.
Okay, so we will adjourn for today then until 9 o'clock tomorrow morning.
Can I just, I'm sorry to interrupt, just to signal I'm got a hearing tomorrow, so I'm not going to be here, but I am going to have someone taking notes for me, so I think we've had a good chat about timeframes, and I'm very clear what's needed, but feel free to send that to the camera and it'll land back with me, and I'll talk to Shelley as well as we go.
And I guess to all that are here now, thank you for the way that things have progressed today. I think it's an excellent day to get to the point that we've got to, and particularly for council, the cooperation between each of you and helping us out, and hopefully we're helping you out in terms of heading everything in the right direction. So we'll see everyone in the morning. Enjoy the southern longer days, and my dogs are up and awake at 5:15 this morning because it was light.